criminal law professional responsibility crossover question from July of 1996 is another difficult crossover question. It's difficult mostly because one has to organize very carefully and because the criminal law aspect is testing one of the inchoate offenses. So we've got to be on guard to carefully use all of the facts, and we also have to know a fair amount of law. This is material that often is tested on the multi-state and which comes up on the essays regularly enough for it to be worth our while to study. But it doesn't come up as often as many of the other issues. Take a look at the two calls of the question. 1. As to which, if any of the defendants, would the above facts support conviction of the charged offenses, and on what theory or theories? Discuss. Well, we don't yet know what those charged offenses are, but we'll be organizing probably by the defendant, but possibly by the offense. And then we'll connect the facts of each defendant's conduct with the elements of the legal charges that they are facing, and then we'll reach a conclusion about whether or not they're guilty. Then, in call number 2, we are asked, has Lex violated any rules of professional conduct? Discuss. Well, here again, we can organize around the legal principles of professional responsibility, the duties that are owed by an attorney to the profession, or we can organize around the facts and then apply the standards to the facts that are used as organizing principles. Either way is usually acceptable. So here, looking at the two calls of the question, there are a couple of different intuitively sensible ways to organize the material. And as it turns out, either one of them is entirely acceptable to the Committee of Bar Examiners. And, as always, I also should acknowledge that several, maybe many, answers that we're passing were just 4 or 5 big, long, fat paragraphs with no headings. But I think you'll agree, it's easier to think in blocks of material, and it's easier consistently to write well if we are rigorously organized in advance. So now let's go to the top of the fact pattern and let's have a look at the details. As it turns out, another thing about this question that's kind of tricky is that we don't get the charges until the very end. So please go to the top of the fact pattern. In paragraph 1, we meet Dan, presumably our lead defendant. He owns and operates a messenger service using bicycles, and he's also a heroin dealer. Some packages contain heroin that is sold to the recipients by Dan. And we've got 3 messengers, Al, Bill, and Craig. It turns out that these are our 4 defendants. And that makes organizing this answer a little bit easier, and it makes writing it a little bit more difficult, because we have to confront many issues during our 1 hour's time limit. Next, we learn the facts about the 3 different messengers. In paragraph 3, we learn about Al. He's worked for Dan for several months. He has never discussed the heroin sales with Dan, but he has inspected some of the parcels himself, and he knows that heroin is in them. Dan suspects he's aware of the heroin and pays him a lot more than he pays the standard messengers in order to keep him happy. Okay, well, it looks as if Al is going to be guilty of plenty of heroin charges fairly soon. And also it seems as if Al and Dan are conspiring, even though they don't have an express agreement. In paragraph 4, we learn about Bill. He doesn't know that the packages contain heroin. He suspects they do, but he doesn't care. And he receives a standard wage. Well, his suspicions, are they enough to convict him of heroin charges? Maybe yes, maybe no. As you might suspect, I would be inclined to go against convicting him because of my defense bias. Now, go to paragraph 5 and we learn about Craig. He's a new hire, he suspects nothing, and he gets standard wages. This guy is innocent of anything that might be charged. Let's see if any of the facts that remain will change our minds about any of these assumptions. In the last paragraph, or next to the last paragraph, Bill is worried about his participation. He takes a suspicious package to Lex, the lawyer, and now we get the PR issues. Bill never examines the contents, but Lex does. He finds heroin in the package, and then all he does is reseal the package. That's a violation of ethics right there. He doesn't tell Bill what's in the package, but he hands it back and says, what you don't know can't hurt you. Oh, yes, it can. Then Dan's scheme is discovered. Craig has an accident and a package opens. Heroin is revealed. Then all four have been charged with sales and transportation of heroin and conspiracy to transport heroin. So they are facing more than one charge, 3 charges apiece. And then we get the call of the question. Now, please turn to the outline of issues that I present, and here we're almost given the organization, and we'd better take what they give us. So I focus on each defendant separately, and then within those charges, I focus on sale, transportation, and conspiracy. If it struck you as being easier to organize around these different charges and then have internal sections about each of the defendants, well, that's fine. It's entirely acceptable. What we are looking for is clear organization. I do it this way because intellectually I find it easier to go through the liability of each defendant separately. But plenty of successful applicants found it intuitively more sensible to organize around the charges, and that's fine. So looking at the remainder of the outline of the first call of the question, we just go through the 4 defendants, and that's it. Then we turn to the PR issues. Clearly, this is by far the less important aspect of the question. Still, I organize around duties to the profession and duties to the client, because I think this allows us to do the most thorough job in explaining just what a loser this lawyer really is. He's let down the profession, and he has let down his client. And that's basically the end of the story, or shall I say, that's the end of the organization of the story. So now please turn with me to the answer, and let's have a look at how the story plays out in an accurate, well-organized model answer. Notice up front, I don't have a separate introduction of any kind for this answer, and the reason is I just don't think there's time. Given how many issues we have to address and how little time we've got to do it, I think the best approach is to just get to the point, answer the questions, and then breathe a sigh of relief that it's over. So, with regard to Dan, focusing on the sale of heroin charge, well, I lead with the fact that this guy is a heroin dealer and that he doesn't appear to have any defenses, so I convict him of the charge. It's very simple. This is not a crim pro question, and there are no facts on the side of the defense. Okay, I have a pro-defense bias, but when I look at facts like this, I find for the prosecution every time because the defendant is clearly guilty. Next to the transportation charge, here the key fact is that Dan doesn't personally move this dope around. He's got drivers that do it for him. And that means that we have to analyze it based on vicarious liability. And still, that's good enough to convict Dan of transportation, because the mere fact that he has agents act as delivery people for him doesn't absolve him of responsibility for those deliveries. Again, it's plain and simple. Dan is liable. Now we turn to conspiracy, and here we can establish a conspiracy even in the absence of an express agreement, because the facts show an implicit agreement between Dan and Al. And if you look at that paragraph right at the end of the section on Dan, I think you'll see some factual analysis that is pretty hard to dispute. Although, believe it or not, some people wrote successfully that Al shouldn't be convicted. Now, I think they're dead wrong, but they still receive passing scores. So now we turn to Al. Here, I lead with what I think is the most important fact once again. Al never exchanged money for drugs, and he never discussed the heroin sales with Dan. Still, he has covertly inspected packages, he knows some of them contain drugs, and he's getting paid a lot extra because his boss suspects his suspicions. So it's clear that Al is guilty of heroin sales, and he's also guilty of transportation. And I do this in simple declarative sentences, again, because the examiners have given us nothing to work with on behalf of the defense. Similarly, with conspiracy, we've already covered this issue with regard to Dan, and the agreement was between Dan and Al. I think that's good enough for a conviction. Next, we turn to Bill, and here I do lead off with a paragraph of facts. Bill never knew that these parcels contained heroin. He suspected they did, and he didn't care, and he got paid regular wages. He consulted with a lawyer, and the lawyer told him that he didn't have anything to worry about. basically, and I think that's good enough to find Bill innocent. And although I like to joke about my alleged pro-defense bias, I think that's the clear, correct answer to this question. Bill never sold heroin, and that's clear in the analysis that I present under that charge. Plus, he consulted with a lawyer, and the lawyer breached his duties both to the profession and to the client by failing to end this problem right when he could have done. But I say Bill is innocent of sale of heroin because he is factually ignorant of the truth of his conduct. We move to transportation of heroin, and here the defendant Bill did deliver packages that had heroin in it. But he didn't know they did, and he didn't care, and he didn't get paid extra. Plus, his lawyer didn't tell him to stop doing it, and I think that's good enough to absolve him of liability for transportation. Here again, I can acknowledge that some people wrote contrary answers and got passing scores, but I'll give you the correct answer to the extent I've got an opinion about it. Finally, with regard to conspiracy, of all of the charges faced by Bill, this is the thinnest of all. There was never any understanding between Bill and Dan with regard to delivering heroin, neither explicit nor implicit. Finally, we turn to Craig, and I also think Craig is innocent of all the charges he faces, and I lead with both the facts and that conclusion before we get into the three charges that this defendant faces. And here, I think this is the easiest defendant to analyze, and it takes the least amount of time. The bottom line, this guy didn't do anything wrong, and he shouldn't be convicted of any of the charges that he faces. Finally, we turn to the PR section, and I think this is actually fairly difficult, not because the facts are tricky, they're not, but because one really has to think carefully to figure out just how many offenses have been committed by this lawyer. This conduct by Lex really is dreadful, and it's dreadful on many different levels simultaneously. Notice how, upfront, with this case, I lead with the facts. I explain exactly what the lawyer did, and I'm more or less quoting from the facts as I do so. I explain also that not only is this lawyer going to face potential liability in disciplinary proceedings, but he also might be criminally liable too. First, I focus on duties to the profession, and here's where I think the lawyer may have committed a crime. By his failure to intervene, he becomes a knowing accessory to the sale of heroin and the transportation of heroin, and perhaps even a co-conspirator, although I don't go quite that far in the answer. The lawyer has a duty to the profession not to participate in criminality, and what he should have done, I discuss below. Next, we consider the duties to the client, and here the lawyer was incompetent. And I think you'll notice, after you read a number of my PR essays, I think that a lot of the lawyers on the bar exam are incompetent, and they also often breach their duty of zealousness, particularly in criminal cases, but also not infrequently on the civil side as well. So with regard to the duty of competence, we examine the facts. This client, Bill, came to Lex because he was worried about possibly being mixed up in heroin sales and transportation. And if Lex had done a competent job, he would have told Bill that the package contained heroin, and Lex would have advised this guy to stop working for Dan. Competent advice would have prevented Bill from being arrested and prosecuted altogether. So, this lawyer, Lex, is liable for professional lapses. Next, we turn to the duties to the profession. Here, a lawyer, the duties of zealousness, actually. The lawyer has to aggressively protect his client. And by just returning the package to the client, he knowingly exposed his client, Bill, to being arrested and prosecuted for serious felonies. And what he should have done was advise his client to quit and then act accordingly. So, Lex is going to be subject to discipline both for being incompetent and for failing to be zealous. And, as it turns out, his client, Bill, in my analysis, ultimately will be absolved of all the charges that he faces, but had Lex done a competent job, he wouldn't have been charged at all. And that wraps up a consideration of a PR criminal crossover question that posed a fair amount of problems for a number of the people who took it, including, hopefully, you, because you'll learn an awful lot from your mistakes, and it's easier to learn from doing things wrong than from doing things reasonably well.